So we are on, perfect. So good afternoon, everyone in China, Asia, but also good morning or very early morning to the US, because we have Mike with us. My name is Andrea Chmielewski-Bigazzi. I have the pleasure of being the coordinator of PrivacyRules, global alliance now present in 56 countries around the world on privacy, data protection, cybersecurity, and communications. Our family is broadening. We are now present in 56 jurisdictions around the world, and we are growing. And today we have the conclusion of a long overflight around the world. We started 2 days ago in Latin America with PrivacyRules experts in Latin America. And yesterday we were present in Europe, and we are landing now in China and evidently speaking to the Chinese and the Asian markets. Today we'll be moderating this session, the co-host of the event, which is Jihong Chen from Zhonglun, one of the leading law firms in China for full service, obviously, but certainly high specialization in privacy and data protection. And Jihong is also the co-chair of the Asian Committee of PrivacyRules, together with Yingyu Wang, who's speaking to us from Singapore. The law firm Taylor's Winters Weir, high specialization in data protection, IT law, IP law in particular. We have, again, from Asia, Akira Matsuda from Iwata Godo, a leading law firm, Japanese law firm, again, highly specialized on data protection, and also Akira is a great expert in GDPR. So he has this very great comparative approach. And then we move west. We arrive in Italy. We have Luca Egitto from the law firm RMP Law and Tax. It's one of the leading law firms in Italy, present in multiple countries. And then we continue and finish with Mike Nitardy from the United States, Frost Brown Todd law firm. And he's leading the privacy practice within the firm. The firm has a team of more than 30 experts, lawyers just dedicated to privacy. I would conclude here thanking also the team of PrivacyRules and Alessandro Di Mattia in particular for organizing these two sessions event. We will have another session that I will introduce afterwards, but I would like to pass immediately the word to Jihong. Jihong, thank you very much for co-hosting this event again and for moderating now. Thank you.
Okay, thank you, Andrew. Hello, everyone again. Thanks for joining this session. And the main topic of this session will focus on e-commerce regulatory framework from the perspectives of Asia, EU, and USA. I am Jihong Chen, introduced by Andrew, and I am the partner of Zhong law firm, a Chinese full-service law firm with international coverage. I am the moderator of this session, and beside me, we'll have four excellent speakers. And just introduced Akira, Yingyu, and Luca, and Michael. As you may realize, that we are now in the era of digitalization, particularly driven by the COVID-19. And China, as a major economy of the world, is a pioneer in the digitalization process. And first, I will take a few minutes to introduce China's new trend on the data protection and cybersecurity law. I'd like to share my screen with you. Okay, let's get started from China's legislative progress. China promulgated the first comprehensive law, cybersecurity law, in 2016, and this cybersecurity law came into force on June 1st, 2017. And this is first comprehensive law of China regarding cybersecurity and data protection. In last year, 2020, China speed up the legislation regarding the data protection. In October 2020, China National People's Congress and actually announced two drafts. The first one is the Personal Information Protection Law. Another one is data security law. And in this year, in last April, the National People's Congress announced the second draft of these two draft laws. And as I expected, and the two draft law will be passed by the National People's Congress. And by the end of 2021, this year, and these two important law will come into force in the early of 2022. So after the two draft law, the Personal Information Protection Law and the data protection law, data security law came into force in this year, China will have three basic laws. The first one is cyberspace law, cybersecurity law, and personal information law, and data security law. This will constitute the three pillars of cyberspace administration and data protection. And for the cybersecurity law, and this will regulate the multi-level protection scheme. We call it as MLPS, and network critical device and dedicated products testing and certification, and CII, cybersecurity protection, cybersecurity review, cybersecurity monitoring, early warning, and information notification. And this will be the main role of cybersecurity law. For the personal information protection law, and this law will regulate the scope and definition of a PII and basic principles on PII processing, right of data subjects, rules on data localization and cross-border data transfer, PI processors obligation. For the data security law, and it governs the data security standardization, data security testing and evaluation, a system, classified and graded data protection, important data catalog, and important data cross-border transfer, etc. And these three laws will be the three pillars for Chinese cyberspace administration. Let's talk about the PI, cross-border data transfer. And before the personal information protection law draft, Chinese has no clear rules on the cross-border data transfer of PI. But after the personal information protection law, it seems that China clearly defines the rules, the ways for the cross-border data transfer. Actually, there's three basic and legal ways for the PI cross-border data transfer. Number one, and passed the security assessment organized by the government. The government should be CAC, China administration of cyberspace. And second way is conducted a personal information protection certification by specialized institutions and maybe appointed by the government. And third one is enter into the contracts with the overseas recipients in accordance with the contract formed by the government. And this way is quite similar with GDPR, SEC. So basically speaking, there are three legal ways for conducting PI cross-border transfer. But before you can conduct a cross-border data transfer, there's other additional formality requirements. For example, and the data controller need to secure a separate consent from a data subject. For the CIO, and they need to fulfill the obligation of data localized storage. In draft personal information protection law, and there's a strict regulation on PI request by overseas judicial authorities. Let's imagine if there's a overseas case handling by the overseas courts, and if the overseas judicial authority request maybe the PI from Chinese entity for PI stored in China, and the Chinese data controller first need to get approval from the Chinese authority. Only with the approval, the Chinese data controller can provide the PI to the overseas judicial authorities. If any Chinese entity violates this provision, there will lead to the punishment, mandatory punishment. And also in the draft law, it provides countermeasures if any foreign authorities set any discriminations on Chinese entities or Chinese government regarding the data transfer or data processing. Chinese government may, in accordance with this law, take countermeasures against foreign government and foreign authorities. About the important data, as you may know, that important data is a very unique concept under Chinese laws. And what is important data? According to law, if the data is leaked or abused, it may directly affect the national security, social order, etc. This data will be regarded as important data. For important data, and if the data controller is a CIO, I mean critical information and infrastructure operator, and the CIO need to fulfill the cross-border data transfer specified by the cybersecurity law. That means first, and to pass the security assessment organized by the government, and then can you transfer the important data to overseas recipients. And for non-CIO organizations, and the CEC will formulate the special rules on cross-border data transfer of important data, especially. Let me see the data security law. There's regulation on cross-border data transfer beside the PII. And actually, in the data security law, Chinese provides a very basic attitude. China will promote the cross-border data transfer in a secure and free manner. It is a standing of Chinese government. And for some special data related to the defending national security and interest of performing international obligation, and this data might be subject to export control, and this export control should be with a license from the government first. And for the countermeasures, and in data security law, there's a countermeasures provided by law. If there's any foreign government take any discriminatory measures on China in terms of data activity, Chinese government may take the equivalent countermeasures against any foreign country. For the enforcement backup, regards request by overseas enforcement organization for data stored within China, such data should not be provided without the approval of competent authority. So this is the whole picture telling you how Chinese new law will be treating the data cross-border transfer. I will finish my introduction, and then let me invite our speaker, Yingyu. Yingyu is managing director of Taylor Winter, we are LLC of Singapore. And Yingyu is now in your turn.
Thank you, Jihong. Hi, everyone. Alejandro, may I kindly have my slides, please? Thank you. Just to bring everybody back to the topic for today regarding e-commerce. We know that e-commerce collects quite a bit of data. I would just like to share from a Singapore perspective, two things. One, as an e-commerce retailer or e-commerce marketplace, what are the things to take note of? And the second thing would also be as a data center hub in APAC, what are the things to take note of? Because we have had clients whereby the data is stored here, even if they do not have a market here. All right. So if I could go on to the next slide. These are just a few of the e-commerce entities that got into trouble with the PDPC last year. PDPC is the governing authority for data matters in Singapore. Lazada is actually owned, I think, connected to Alibaba, and RedMart. For this particular one, RedMart was an acquisition that they made quite a few years back. The data that was breached was actually from a legacy database that is no longer in use, apparently. Then there is Shopback, which is quite big in Singapore as well. What is particularly interesting to me was the fine that was levied against this small e-retailer called Novelship. Actually, Novelship uses a third-party payment processor, right? And it is basically a website that sells designer sneakers. But it was fined because a user could actually access up to the data of 6 sellers that were on the website. And the PDP, even though the fine wasn't that big, it was about $4,000, but it was interesting because the PDPC actually fined a small individual e-retailer, right, for not conducting sufficient vulnerability scanning, which for a small player is something that probably did not cross their mind. So I think this is a reminder, I think, for all e-retailers, especially now with COVID-19 happening and most of commerce being conducted online, that this is something that the PDPC is looking into quite stringently. So if I could go to the next slide. I'd just like to go through some concepts that I think are relevant from an e-commerce perspective. As everyone knows, Singapore is generally quite friendly. We are business friendly, I mean. But I think in order to gain prominence and also to gain trustworthiness as a data center, the PDPC has come up with balancing factors, right? To ensure that while data can be used well in a business perspective, it's also properly protected. And by data, I mean personal data only. So from a Singapore perspective, the consent regime, in my view, is generally quite wide. So other than the explicit consent and implicit consent, the original obligation has a deemed consent, which is actually quite useful for controllers, because by conduct or contractual necessity, you don't have to seek explicit consent. But in the new amendment, which took effect this year in February, there is a removal for need of consent. And I think this is interesting for MNCs who store their data here. I will go quickly to what we call the business improvement. So essentially, if a user or data subject only gave consent to one entity in the company group, there is no need to seek his consent, right? If the data is to be moved to other groups to other companies in the group, if it's useful for business improvement. And this is actually defined quite widely. It could be, it could be data crunching to see what sells best in a certain jurisdiction, in a certain age group, right? But this information cannot be used for direct marketing by other entities within the group. So I think this gives actually quite a wide bandwidth to companies who grant access of data to other employees in other entities, right? But this has to be balanced, right? Because once you grant access to other entities within your group, you're still subject to transfer limitation and accountability obligations, which obviously can be worked out through intra-company agreements, just to ensure that the standard adhered to in the other entities the same as the standard adhered to in Singapore. Right. But what actually is also interesting is that beginning of this year, in February 2021, we have put in the data breach notification obligation. As you can see from the 3 examples that I gave earlier, they all happened end of last year, right? So there was no real need for them to notify PDPC or affected individuals of the data breach, but this would not be the case now. Okay, the second thing would be the introduction of criminal offenses in the PDPA. It's a maximum of $5,000 fine or 2 years in imprisonment or both, right? So obviously the threshold for this would be high because you need to knowingly or recklessly have committed unauthorized acts, but it does show a certain stance that's taken by PDPC. But most importantly, which is still not, this has already been passed, but still not put into effect, would be the enhancement of the maximum financial penalty. In the past, based on our perusal of fines, the maximum that has been levied was $750,000, which is really quite little compared to a lot of other jurisdictions. But it has now been stated that the maximum financial penalty would be 1 million Sing or 10% of the turnover, whichever is higher. I think this has created some waves, even though we do not know when it will be implemented, but it will come. So there are a lot of organizations, I think, that are looking into this, paying more attention to PD obligations right now as compared to before. If I can move on to the last slide. Thank you. Okay, so we have, I thought this was quite interesting, the TR76. The TR76, it's the Technical Requirement 76. It's the first standard issued for e-commerce by the Singapore Standards Council. This is just a guideline. It's not meant to be legally binding unless there are portions of it that some authorities adopt. But having said that, I have picked up some data-related issues that's been set out in the guidelines, because I think that this would lend an argument for e-commerce marketplace operator or third-party service provider that, hey, this is what is expected of me from a business improvement or a legitimate interest perspective, right? So I think this will help, again, with the removal of the need for consent. So one of the things that I find interesting is that retailers and e-commerce marketplace, they are encouraged to use AI ML to track preference and recommend suitable content and enhance engagements. And this necessarily means that they have to collect data and use the data, right? Of course, then there's the need to inform customers about the tools, your cookies, your mobile apps that retrieve location data, etc., and the stored profiles for repeat customers. For e-marketplaces, they are also required to keep information in relation to the merchants so as to sieve out fraudulent merchants. But what I find more interesting is that in order to sieve out fraudulent merchants, they will also require data points on the orders. And this may then necessitate personal information in relation to the customers. So actually, I mean, and also there needs to be a requirement to keep inquiries, feedback, and complaints. Again, likelihood that there would be personal data involved, right? So the other thing that e-retailers and e-merchant, e-marketplaces are recommended to do is to keep stored profiles, right? So that during orders, they can do cross-reference to past orders to ensure validity of the orders. And of course, the last bit would be the payment security issue, which I will not go through. It's a lot of very highly technical things, but there is an encouragement to adopt ISO. This could be actually quite onerous for e-retailers, especially for the small players. But from the TR76, what I gathered is that there is this encouragement to use data, a lot of it's personal, to enhance standards of e-commerce within, amongst the ecosystem. So with that, again, like I mentioned, if we go back to the slide previously, right, about the different concepts that's relevant, I think it's, again, a balance of encouraging businesses to use data, and on the other hand, making sure that there is sufficient protection. In my view, I think the local retailers, the e-retailers, are still a bit far off from what's required, particularly with the fine that's been levied on novel ship. But I'm quite excited to see how this would develop in time to come, especially in the e-commerce space. Yeah, so that's all for my presentation today. It's very short and very brief. Hopefully it's useful.
Thank you, Yingyu. And next we will invite Akira from Japan to give his presentation. And Akira, it's your turn now. And besides I would reminder that each speaker will have 8 minutes to give his presentation. Thank you. Akira, I see you are muted. You need to turn on your microphone.
Excuse me. Thank you, Jihong. Hope you all see my slides now. Hello, everyone. My name is Akira Matsuda, partner from Iwata Godo, a Japanese-based law firm. Today, I would like to talk about e-commerce related data in and out of China. I have 2 main focuses today. One is the overview of the e-commerce regulations in Japan, and the other is very coincidentally, almost the same time as in China, we are expecting the overall amendment of our personal data regulation, which will become effective next year, April 1st. So I will touch about what is going to change with this amendment. First, I will start with the overview of the e-commerce regulation in Japan. And when I talk about the e-commerce regulation in Japan, important point is the extraterritorial application to foreign entities. This means that if the foreign entities are having sales or marketing activities to Japanese residents through the e-commerce platform, the Japanese regulation will be applied extraterritorially. The main focus of the regulations that is relevant to e-commerce could be classified into these 5. One is the personal data. One is the marketing regulation. There are also advertisement regulations, consumer protection regulations, other sector-specific regulations such as electronic appliances or pharma. Today, I will focus on the first 2. As I explained, the amendment of the personal data regulation in Japan is expected soon. I will touch on this later. I will start from the marketing regulations that is relevant to e-commerce in Japan. Largely speaking, there are 2 kinds of marketing regulations. One is the email communication, and one is on direct marketing. When you are an e-commerce platform provider and providing services or goods to Japan, both of these regulations will kick in. For the email communication, when you send email to the recipients in Japan, either of these four should be met before you are sending an email. So first, if you obtain the consent from the recipient, you can send the email. Second, if the data is received in writing from the recipient, you may send an email. Third, if you already have an existing business relation with the recipient, you may send an email. And fourth, if the recipient puts email address on the website for their business purposes, you may send email without their consent. I'll move on to the direct marketing regulation. The same as email communication. First, if you have consent of the recipient, you may send direct marketing messages. Second, if the email advertisements are with notice of matters regarding a contract to be entered into the recipient, you may send a direct marketing messages. Third, this is an exemption on newsletter, as advertisements on newsletter which are sent with recipient's consent, you can do a direct marketing activities. As you can see, if you obtain consent from the recipient, these regulations will be complied with. So the most prevalent ways of clearing these regulations would be to obtain consent from the recipient when you are first dealing with the customers. Okay, because the time is limited, the second focus is the amendment of the data protection regulation in Japan, which will also largely affect the e-commerce platformers who are providing services or goods to Japanese residents. So as I explained, amendment will become next April, effective next April. So currently, already the law and the sub-legislations have been approved by relevant bodies. Currently, draft of guidelines have released last month, and this is under the public comments period. We expect that these guidelines will become final by fall this year, and then it will become effective next April. So there are several points on the amendments, and I will touch each by each. The first is the mandatory data breach notification regime. Currently, this is a best effort basis, but after the amendment, certain categories of data breach you need to notify either the Data Protection Authority Japan, which is called Personal Information Committee, within 30 days after recognition of the current or potential data breach, or you need to notify the data subjects if it is necessary to protect the rights and interests of data subjects. And 4 categories are listed, which are targeted under this mandatory data breach notification regime. The first one is where more than 1,000 data subjects' data is compromised. The second is where the data breach involves sensitive personal information. The third category is breach with illicit purposes, such as hacking, stolen of data, or by cyber attack. The fourth is possible property damage. So for example, when the credit card information is included in the data which is compromised, and then such credit card information could bring harm to the holder of those credit cards, this is also under the data breach notification, mandatory data breach notification. The second point is the expanded data subjects' rights. So expand means in both the scope of personal data. Under the current law, if the data is deleted within 6 months after collection, these data are out of the scope of the data subjects' rights exercise. But after the amendment, any kinds of data will be personal data will be subject to the data subjects' rights exercise. The second, expansion in correction, suspension of use or third-party transfer. So if the operator is requested of correction, or suspension of use or third-party transfer, generally speaking, the scope where the business operator must respond to those requests has been widened compared before the amendment. The third is the scope of what is required to disclose to the data subjects if there is a disclosure request, and that is a third-party transfer record, which is currently do not are not required to disclose to the data subject, but after the amendment, this record is also under the target of disclosure. Third, new categories of data will be set forth. There are two, pseudonymized personal data and personally referable information. The first one is very identical to that under the GDPR. So pseudonymized personal data could be used for example, AI analytics within the corporation without obtaining consent from the data subjects, if it satisfies the requirement of pseudonymization. The second, personally referable information is very unique across the globe. I think this definition only exists in Japan, but this is targeting the cookie regulation. I may have time to describe this regulation somewhat more in detail in the Q&A session with Jihong later.
Okay.
The fourth is the cross.
Yeah, Kiro, go on, please.
Okay. Thanks. The fourth is the cross-border transfer, more stringent restriction on this. So when you transfer the personal data out of Japan based on consent of the data subject, there is a disclosure obligation on information of the recipient country. So for example, if I'm transferring personal data to China, and that transfer is based on consent of the data subject, you must disclose to the data subject information regarding China, what kind of protection your data will be given in China. The fifth is a stricter regulation on purpose of use or appropriate use of information, somewhere the catch-all clause. This is to ensure that you describe the purpose of use sufficiently, and such as if you use the data for AI analytics, in Japan, for the processing activities, we do not have like a legitimate different from GDPR. We don't need to obtain consent or have a reason for legitimacy for processing activities, but you need to disclose more sufficiently in detail in the purpose of use, what kind of processing activity you are relevant to your processing activity in the organization. The sixth and the last one is a stricter sanctions, and I think this is in line with what is aiming at Singapore. So now criminal fines are up to 100 million JPY. This is equivalent to slightly less than $1 million US. So compared with other jurisdictions, much lesser, but this is a big step forward that the Japanese government has shifted gear to increase the potential fines for breach of the data protection regime. And we also have an imprisonment which can be imposed together with the fines or solely with imprisonment. Slightly, it's not very long, but up to 6 months of imprisonment period. Thank you very much. And I will end this presentation and give the baton back to Jihong.
Okay, thank you, Akira. Actually, for many Chinese companies concerned about the vision of Japanese PIPL, you provide the latest information to them. Then let's move to Luca from Italy. And Luca is a partner and PR, legal and tax. And his topic will focus on e-commerce and GDPR, how to exchange data internationally, complying with regulation. Just a kind of our time is very limited. We have time pressure, so everyone need to finish presentation within 10 minutes. Thank you.
Yeah. Okay. Thanks. So I'm sharing my screen, so this should be okay now. Just let me know whether you're seeing that. Hopefully. Okay. Okay. I'm sorry, I'm having a few troubles and okay. Okay. Right, so hopefully you're seeing my presentation now.
Yeah, I can see.
Yeah, apologies for this. So I'm trying to be quite synthetic on such a broad matter. So I'll try to stick to one of the issues that normally is of concern for non-EU entities when dealing with personal data of EU data subjects. So GDPR came somehow as a novelty for EU and non-EU businesses, although it basically includes consolidated principles of data protection laws operating in the EU before 2016. However, it has a few new aspects that are of very great interest for all businesses worldwide. And this, which is the first one you see on my presentation, I think is the major one. It's some sort of ubiquity principle of data protection laws operating in the EU. So one key issue to take into account is that this piece of legislation, which is one single regulation for 27 countries in the EU, not only applies to controllers and processors located within the EU, but it might apply also to controllers and processors located outside the European Union. Well, why is this of interest is because practically businesses online target users wherever they are, and this could include users in the EU. So if an online business is offering goods or services or is just tracking or monitoring users which happen to be in the EU, then GDPR applies to these non-EU entities. So any business who is willing to operate a retail shop which is targeting EU users should comply with GDPR, even if it does not have physical operations within the union. This implies getting confident with GDPR principles, complying with specific obligations set forth by the regulation. One aspect to become familiar with is that GDPR does not provide specific commands in terms of conduct, but rather sets forth very solid and wide-ranging principles to which controllers and processors need to comply with. So they can be summarized, and in principle, they might seem simple, but they all include a number of subsets that affect the ability of controllers and processors to process data. So personal data should be processed according to the principles that are under Article 5, which is lawfulness, fairness, and transparency. So this is a major principle underlying the relationship between the data subject and the entities processing his or her data, which are the data controller and the data processors. It means that they should process data insofar as they comply with data protection law. They should be fair and transparent, which means they should not process data further than what is necessary, and explain how they do that in a very clear manner. They should carry out processing just for the envisaged purpose and not anything further. They should use the least and the minimum data necessary to accomplish that purpose. They should keep accurate and correct data. they should retain data only for the time necessary to pursue the scope of processing, and they should take any necessary step to preserve integrity and confidentiality and security of personal data. And furthermore, in the end, the major principle of GDPR is accountability. So controllers and processors should be able to demonstrate at all time that they comply with GDPR. So it's not just a matter of compliance, but also a matter of being able to demonstrate compliance. We've been discussing consent in the previous slides. So consent, however, is just one of the legal basis for processing personal data, not the major one, not the main one. They are all relevant, and they should be relied upon after a thorough assessment of the envisaged processing exercise. So consent can be a legal basis, and it should be freely given after being informed. It should be specific for every piece of processing activity which is envisaged. And so consent for a bundle of data processing is not valid. However, a major legal basis when it comes to e-commerce is the contractual obligation. So the controller, which is the vendor in this case, does not need to collect consent when processing is required to process the purchase order, to ship the product, to offer the service that was purchased by the data subject. So this is the main legal basis, because there can be no contractual performance unless personal data is processed. So for e-commerce, I would say that this is the main ground to walk. Then there is obviously another major ground is the statutory obligation, which applies in Italy and many EU countries, for example, under tax laws that require vendors to retain invoices for a certain amount of time. I think that many times these invoices contain personal data of the purchaser. And in that case, the retention of his data is required by law. It's a data processing activity, and the legal basis would be a statutory obligation. Then we have a few more, but I would stick to legitimate interest, which was mentioned above and before, which is thought to be one of the major and most important novelties, although it's not entirely new in GDPR. And legitimate interest is material as well to e-commerce, because it can be a legal basis in limited circumstances for direct marketing. So under certain circumstances, the vendor, which is the controller, can rely on legitimate interest, so avoid consent, to send marketing related emails or communications, as long as they have a relationship with the recipient, as long as the recipient can expect to receive these communications, and as long as there are no prevailing interests of the data subject that prevent such data processing. So this could be very interesting for some vendors to rely upon. I've been mentioned a number of times these two distinct characters. I apologize if these concepts are widely known and already familiar for many of you, but controller is the main target of the obligations. So it's the entity determining the purposes and means of processing. It is the one that sets forth the technical and organizational measures necessary to protect personal data. It has to maintain record of personal data, and it is specifically the vendor of the products or the service provider online. So it's the main target. But we all know that huge quantities of activities are outsourced, and if the outsourcer is engaged also with processing activities by the controller, then we have a data processor, which is subject to the same obligation of the controller when it comes to security of data processing. And the processors, however, may not process personal data unless they have entered into a contract with the controller. And this contract has to set forth all the obligations pertaining to the processing activities and the instructions for the processor to stick with. One last item, which is of greater interest for non-EU controllers, is that if you are a business processing data of EU data subjects, you are bound to GDPR, you're subject to GDPR provisions, and you need to appoint a representative in the EU, which is the recipient of formal communications by data subjects and supervisory authorities. So this is an obligation for all entities acting as controllers from outside the EU with no operations and offices in the EU. I thank you so much for taking your time for listening to me. I hope I have been sticking to the assigned timing.
Okay, thank you, Luca. Thank you. Now let me invite our last speaker, Michael. Michael is chairman of the Privacy and Data Security team and First Brown Touch LLP. Michael, it's now your turn.
Thank you very much, Jihong, and it's a pleasure to be here today. Want to thank the people at PrivacyRules and thank you, Jihong, for having me. In the time remaining, just for the next couple of minutes, I'm going to give a brief overview of trends in U.S. privacy and data security law. That's important if you're going to be doing e-commerce here in the United States. And basically, just to jump right into it, let me go ahead and start my slideshow. All right. So the legal landscape in the United States is different than in other countries. You might have heard it said before, there is no overarching, all-encompassing data privacy law in the United States. Instead, there is a sectoral framework that looks at data privacy from certain sectors. There are federal laws that govern those sectors, and usually it's an alphabet soup of legal requirements. And that's what you see right there on the screen. The federal laws that really come into play are HIPAA, GLIBA, FCRA, COPA, and FERPA. And I'm going to explain as briefly as possible what those are. HIPAA has to do with protected health information. So if you're involved in that, there will be certain requirements. GLIBA has to do with non-public information in the financial sector. FCRA has to do with credit reports for consumers if they're looking for loans, credit cards, and stuff like that. COPA has to do with children online activities, and specifically restricts what e-commerce retailers can do in terms of contact with children 13 and under. And then FERPA has to do with federal education requirements. So these are all really the laws on the national scope that apply to certain sectors in the United States. And as I said before, there is no overarching, all-encompassing law that gives all citizens in the United States that are consumers any type of rights over their personal data, like you have in Europe. But you do have it in some states, and that's what's quite confusing with the United States. Most notably is California, what's known as the CCPA, and that is California, depending upon when you check, has the 6th to 10th largest economy in the world. And so even though it is not covering all of the United States, it's still a significant player on the world stage. And because of that, its consumer privacy law does have an impact and is important for e-commerce retailers to be aware of. Nevada has a smaller law that applies to the state of Nevada, has to do with selling personal information, and not very many entities that are not actually doing business in Nevada or control their own website or that doesn't really apply to many people that we're finding. Now, another area to be aware of is cybersecurity requirements within the United States. And really, this is not being pushed through legislation as much as it's right now being pushed through trade groups, such as insurance trade groups and other financial trade groups, such as the payment processing organizations. And so even though this is not legislation, this could be stuff that is very important for e-commerce retailers to be aware of, these requirements from these trade groups. Not only do you have the cybersecurity requirements from these trade groups, but some states, not all states, but some states within the United States, and there are 50 states in the US right now, have their own state cybersecurity laws, which are required. Most notably, Massachusetts and New York are two that are the most important to take note of and to be aware of, that you're compliant with if you're doing business within the United States. Finally, each of the 50 states does have its own specific state data breach notification laws. And that's important because if you're doing business in the United States and you have the personal information for a resident of one of the 50 states, and that information is somehow breached or misplaced or misused, then you'd have to follow the state law to notify those individuals. And so there are 50 different ones. And so that can be cumbersome. There are also biometric laws, which are starting to grow in importance and in size and in scope in the United States. Most notably is what's called BIPA, which is from Illinois, which provides certain rights to Illinois residents whose biometric information is somehow obtained from retailers or from employers. Basically, at a very high level, there's consent that must be obtained from these individuals before you collect or use that biometric information. There's a lot of litigation going on right now around that. And finally, and perhaps most importantly for today's conversation, is the aspect of data transfers and whether or not there are any restrictions on those. Right now in the United States, there is no restriction on taking data out of the United States. For cross-border transfer, the United States takes a very hands-off approach currently. It does not believe in data localization as of right now. And so because of that, there are no transfer restrictions. One big caveat to that is certain state governments or local governments within those states may have specific offshoring laws as it relates to the entities that are doing the work for the purpose that you're transferring information outside of a state. So that's something to pay attention to and to consult local attorneys on. And that's all that I have at this time. And so thank you very much for having me.
Thank you, Michael. And we need to complete our session and 4. It seems we have no time to conduct Q&A. Yeah, but the Q&A is quite important for us, and particularly for the cross-border data transfer for the e-commerce sector. Finally, I may raise a general question for all of you, and the question is concerned from many Chinese enterprises. Are there any registration or licensing requirements for entities doing e-commerce business in your country? And Michael, is there requirements in USA?
So basically right now, the main requirement for doing e-commerce business in the United States is going to be just complying with the numerous laws and regulations from the Federal Trade Commission, the FTC. And the biggest one that I think that I would point to would be the Unfair and Deceptive Trade Practices Act. That's the #1 way that they enforce the flow of commerce, e-commerce in the United States. So as long as whatever you're claiming to be providing publicly, it correlates with what you're doing, then you should be okay with the FTC. Specifically, if you want to have legal rights to redress in the US, I would recommend that you get licensed somehow as a business to operate as a foreign entity in the US. But other than that, there's no specific licensing regulations.
Yeah, Yingyu, is there a registration or licensing requirements in Singapore? Yes or no?
No, but if you do some payment services, then you will need to get licensed for that. And of course, there's the usual consumer protection law that you have to comply with. Yep.
Okay, Akira, in Japan, what is condition?
The same as Singapore, we do not have registration or license requirements simply because you are engaged in e-commerce business. However, some sector-specific regulations, such as you are providing a kind of a payment provider services, or if you are selling second-hand goods, in those cases, you need to obtain a dealer's license or registration.
Okay, Luca, in Italy, what is the requirements?
I'm muting. Yeah. So there's no licensing requirements either in Italy. So you can do that as long as, and I would say that it's similar to the US, as long as you comply with mandatory provisions protecting consumers, then you're okay. And GDPR is one of these provisions as well, although it's not for consumers, but you definitely need to comply with GDPR and consumer protection laws. I mean, if you sell from abroad, obviously, if you want to set up physical operations, it's a different story. You need to be registered at the Chamber of Commerce. But if you do online business, there's no preliminary licensing requirements.
Yeah, okay, thank you, Luca. Andrew, I think that is the second session will get started, and for file, we need to complete the session now.
Indeed so, Jihong, thank you very much for managing to condense all this wealth of knowledge within 1 hour. It's truly appreciated. It's always very difficult. I perfectly understand and sympathize with all of you, especially because we have learned today that laws and regulations are changing every single day in your respective countries. So thank you very much for having driven us there and also projecting us in the future somehow. We have seen some of them entering into force in 2022 and so on and so forth. I want to reassure everyone in the audience, we had several hundreds of registrations for our session, but everyone was asking, can I receive the recording afterwards? So the answer is yes. We are going to publish the recording of this event, and in particular, we are going to disseminate reports about it to try to condense the knowledge of our experts in a way that actually can be taken to your respective companies next. Of course, you can find on PrivacyRules platforms the contacts of all the speakers, so they will be present there, so you can contact them directly for any additional requests you might have. And I want to warmly thank again the 4 speakers and Jihong, and I immediately introduce the next ones. So we have Padraig Walsh from Hong Kong, who is also the chair of the PrivacyRules Know-how and Training Committee, who will be moderating this session from Hong Kong, as I said. And we have as speakers today, Francis Chan. Francis is a senior equity analyst at Bloomberg. We have also as a guest in our panel, Brent Barnes, who's the co-founder and CEO at BuyHive. And then we have 2 cybersecurity expert members from PrivacyRules. We have Guido Moscarella from Italy, the CEO of the Innovri Group. And we have Mike Lowe, who's the director of the cybersecurity services at the Winslex Group, in this case, Hong Kong office sales. So Padraig from Tanner DeWitt in Hong Kong. Thank you very much. We know that you're a fantastic moderator, so the word goes to you for this second session. Thank you.
Thank you, Andrea, and welcome all in all parts of the world. Today we have a packed agenda, and we are going to look at cybersecurity risks in the e-commerce arena, particularly in the context of a scenario we have devised for a growing and expanding e-commerce business, starting from Asia Pacific, expanding to Europe. But the first place we want to start before we go to that scenario is to set the scene. And a lot of the cybersecurity risk that arises in e-commerce derives from financial payment data. In that context, we've asked Francis Chan from Bloomberg to come and give us a scene setter to explore the developments in that space in mainland China around payments, digital currencies, and fintech development that will have a direct flow and connection to the e-commerce arena. So without further ado, I'm going to ask Francis to please introduce yourself and let people know who you are and what you do. And then the scene is for you to take us through that world, Francis.
Thank you very much, Patrick. Thank you very much for having me today. Francis Chan, the Senior Industry Analyst with Bloomberg Intelligence, an independent research platform underneath Bloomberg LP. And I've been covering the Asian banking and fintech sectors over the past decade with the company. And without further delay, I will go through my thesis. First of all, give you a backdrop on how the e-commerce business have been developing in China over the past year or so amid the COVID-19 pandemic. Then to follow up with the payment industry dynamics, especially with more and more crackdowns from the regulators, as many of you may be aware of, on top of the news about Ant's IPO was abruptly halted last November, and the ramifications to, first of all, the payment companies in China, how they can take one step forward from this point onwards. And finally, of course, to give you an evaluation on how the payment business will affect the overall fintech industries in the country. First of all, I just want to take Alibaba, the biggest e-commerce company in the country, as an illustration. In fact, my colleague, the internet analyst with Bloomberg Intelligence, are expecting Alibaba's overall sales or revenue growth to sustain a growth pace of 40% in 2021, which is a very similar growth pace to 2020, when COVID-19 has been hitting the country really, really badly. And in fact, there have been different business segments of the company, but obviously everyone know about that Taobao, Tianmao, domestic retail marketplaces are their major revenue segment, on top of other local services or logistics or cloud computing. So this is still very much a e-commerce company as their bread and butter for what they're making their lives, making a living. So our forecast is even more bullish than what the investment banks consensus would indicate. They only project 30% growth for the revenue this year, but we expect much more, like 40% plus, with the e-commerce business as the major driver of Alibaba's revenue. And China's virus outbreak could have structurally shift online consumption patterns for an array of product categories, and consumers have come to rely more on the e-commerce marketplace and also for the local service platforms for food delivery, fresh produce, groceries, daily necessities. I think it's a global phenomenon, not limited to our country. But when many of the people are staying at home, work from home, this new pattern of engagement will probably persist even after the virus phase, as users may slowly estimate to online convenience. And to adapt to this new trend, many offline merchants in the country with physical retail stores, they suffer a lot during the virus outbreak, and now they look to digital sales options to connect with and sell to their customers. And in fact, to give you some figures as a perspective, online retail sales of physical goods jumped 25% on year-on-year basis in China in the 12 months ended May. That's a much faster pace than only 20% a year ago versus a year ago. And I think more importantly, we see during the same period, there has been a 3% contraction of total retail sales in China. So online sales are really taking over the retail sales, and that phenomenon would be a persistent one in the coming 5 years in our view. So what happened to payment? I tell you something which the market thought originally. There has been a really renowned research organization in the country, iResearch. They have been projecting the overall online payment volume will expand at a pace of about 18% a year during 2019 to 2015. And originally, I agree with that set of assumptions because it's even slower than what we have seen for the e-commerce expansion. But to be frank, later on, I will let you know why I have altered my assumptions a little bit to lower my forecast a little bit. And obviously, just to give you the perspective, the overall online payment volume in 2020 is about 220 trillion won, and which is about 30 trillion US dollars. And if you talk about the breakdown, e-commerce and online service drive consumption payments, which account for about 35% of the overall payment. But there's another block, which is called investment needs and the financial payments. I think those account for another 30% or so of the overall online payment volume in the country. So, I just want to highlight Alipay as China's largest payment platform, produce a very powerful and reinforcing network effect among its customers, business, and partners. And that has been the game in China, the payment game in China over the past 5 to 10 years. But it may no longer be the case because of because of continuous regulatory curbs or crackdown from Chinese policymakers, the politicians. And let me give you a few measures which I think which will make you sweat on how the payment prospects could be undermined in the coming few years. Well, first of all, the government has been going against Alipay and WeChat Pay's anti-competitive practice, anti-monopolistic practices, like they want to, only channel, the consumers or the customers to their own financial products, like their, lending credit products or the wealth management products. That will be forbidden from this point onwards. And, there have been some improper links in Alipay's payment app to, for instance, Ant Group's credit product, in Chinese it's called Huabei or Jiebei. It's basically installment loans for consumers to buy the different kinds of merchandises. Now, Alipay can not only, convey those consumers or customers to these lending products. It has to open up. It has to open up the platform to everyone. Secondly, obviously, there has been a monopoly of personal information, especially for credit investigation, by Alipay, WeChat Pay, and this kind of platforms. They can no longer do that. The central bank of the country, the PBOC, is stepping in, share all the data with me, and I will be the master. I'll hold the master of all this personal information. So Ant Group, Tencent's WeChat Financial, the unit, Baidu's unit, like Du Xiaoman or JD Finance, all these kind of leading platforms in the country, they can no longer hold the personal information on their own. And that really compromise the payment development, because payment itself doesn't generate much revenue. It's about how they convert those traffic to fintech products to turn them into to monetize those traffic. That's how the payment platforms are making money. And there are some other regulations or curves, such as asking Ant Group and later on maybe Tencent's finance units or JD's finance units to package all their financial units, including their payment platform, into a financial holding company coming under the scrutiny of the banking and financial regulators of the country. And of course, some leverage and systematic risk control over the aggregate fintech business of these big financial firms, big fintech firms. And finally, the sale of products, like there has been the flagship product of Ant Group. A lot of them sold through the Alipay. Its name is Yuobao. Once has been the largest money market fund sold online in the world. Its balance has been declining by 30% over the past 6 months because of the regulatory curbs. So these are just some of the backdrops of how the Chinese government could be going after the the biggest fintech company. And this kind of curves have been expanding not only to the fintech firms per se, also to technology companies. Some firms like Pinduoduo historically is doing some package sales of merchandises domestically in China. It has its own payment app too. Now, I think they have to apply for license and come under strict regulation for their payment business. ByteDance, as you may be aware of, in the overseas market, TikTok, they got their payment apps too. Now, that payment app has to apply for license and to face more restrictions. And many others like Didi, which is the Chinese version of Uber. Same problem, same kind of crackdowns. And as a result, I think based on our analysis, the overall payment volume in China could be slowing down to single digits, like 9% a year from the previous 18% I cite from iResearch. That's the first thing. And more importantly, some bread and butter for the payment platform, which these payment firms rely on for their revenue generation, like credit and wealth markets, I expect them to shrink by about 23% on an aggregate basis by the year 2025. So that summarizes my brief presentation on the current e-commerce and then the payment marketplace in China. And I'm very happy to discuss on some other areas later on in this section. Thank you very much.
Thank you so much, Francis. Taking up on some things from there, what is clear is that payments and e-commerce are essentially, if not quite bedfellows, certainly in the same darkened room together. And one of the things that's quite interesting there and will be consistent as we move forward to the scenario and the slide deck that we're going to go through with the remainder of the panel, is that the COVID pandemic has resulted in a significant uptick in respect of e-commerce businesses. And this is true globally. What that has meant is that businesses have had to scale and grow very, very quickly. So if I could ask my friends at PrivacyRules to bring the slide deck to the screen now. And we can briefly start with a review of the scenario that we're going to explore. So the scenario we have in mind is a business that starts out from Hong Kong, which is an online e-commerce business-to-business solution, a source and supply business. So if you move forward one slide there, please. This is a business which is young, which is agile, where the founders of the business have got domain experience in the industry, but are not coming from an IT or technical expertise. Their customer markets are in the EU. Now, moving forward one slide from there, the first scenario that we're going to discuss with our panel is a situation where this particular business, Source Secure, has a core and key client in the EU, based in Italy. That client has demanded that they have a same time zone business presence. That means that Source Secure must employ a person in Milan who will service that client and conduct the client-facing work required for their business on site. This is their first office outside of their home base in Hong Kong. If I could ask first to one of our panelists, Brent, please. Brent, first, spend a moment to introduce yourself and your business. But what I'd like you to do then is to go ahead and just maybe briefly explain, as a business owner in an e-commerce business that is expanding in this way, what's going through your mind when you're opening a new office in another location? where does IT, cybersecurity, data protection sit within the range of priorities that you're facing in that dimension?
Thanks, Patrick. So first of all, let me introduce myself quickly. My name is Brent Barnes, and I'm the co-founder and COO of Byhive, which is a young startup based here in Hong Kong that's focused on disrupting the sourcing business. And we're using technology and transparency and accountability to do that and to deliver profitable products to buyers. So this case study that Patrick has introduced is very close to home for us for many reasons, but in particular because we are a small startup that's growing rapidly and we think about these sorts of things. So the first thing that I would say, perhaps to the shock of some of the people on the panel, is that IT security is very unlikely to be our first priority. It's more likely that our first priority and maybe even our second priority is going to be getting the office set up, right? So basically from an IT perspective, time to market, budget, stability, linkage to the Hong Kong headquarters. And of course, within that scope of requirements would be security. And it would be considered part and parcel of I would say like the stability and connectivity requirement. But it's unlikely to be our focus. And so I would say we would imagine that a vendor, whatever vendor we work with on the Italy side in Milano, would be able to provide the type of IT security kind of standard service that we would require as a small business.
So drawing from that and moving to Guido on this, I mean, what really would be happening here is that you'd be relying on expertise in the market that you're opening up in, basically outsourcing, which means that due diligencing and identifying the right qualities in the service provider you engage in order to provide the office setup and related IT services is going to be core and critical. But Guido, if I could ask you also, please do introduce yourself and your organization, but then maybe move on to explain or explore some high-level points around the cybersecurity risks that might arise when you're dealing with a distributed workforce, where you've got a head office and core IT that's based in one place, but the business has our man in Milan, who is now going to be conducting business utilizing those IT systems remotely in another jurisdiction.
Okay, hello everyone, and thanks for having me here today with you. And I'm Guido, and I'm the COO of Innovery. Innovery is an Italian firm. Actually, now we are present also in Spain and Mexico. And okay, we are system integrator and based and focused mostly on security. Now, to go straight to your question, what would I also recommend for this kind of scenario? Well, I think that actually there's no one-size-fits-all solution in cybersecurity, and there is no silver bullet actually here. So the approach that Brent said, that he said, okay, we are not focusing on cybersecurity first and foremost. The first thing is not cybersecurity in mind. I think this is the approach every company has when starting a new business. It's not uncommon to see this. Here, what I would say is the best approach would be to consult a security firm. And the best approach would be to also put your IT infrastructure in the hands of someone who knows what security is and how to handle security matters. So maybe, and what would they do? They will first do a risk assessment, so assess what your company does and how they treat, how you treat your data, and what data do you manage actually? How big you are? What is your infrastructure? If you have a physical infrastructure or are based only in cloud and only having workstations, for example, it depends. It depends a lot on your kind of business. So the best thing to do is to consult a security firm. As you consult, they will do risk assessment, and then they will give you a gap plan to address and to securely build your environment. So maybe the right question would be, how do I choose this kind of company?
Oh, I think they know where to find you, Guido. Mike, if I could ask you, sorry, we're now going to introduce Mike Lowe from the Hong Kong team of another technical expert that's a member of PrivacyRules. What would be happening on the Hong Kong side in this situation? So you're at home base, yep, and there's an international office that is being set up. What would you be thinking of in respect of making sure that the overall infrastructure and system remains secure as you're moving to international expansion? And of course, Mike, please do introduce yourself and WizLinks first.
Okay, sure, thank you. First of all, let me introduce myself. My name is Mike Lowe, Cybersecurity Service Director from WizLinks Group. We are a Swiss-based crash-certified company in Swiss, and also we found over almost 30 years, and we are very focusing in cybersecurity assessment, and looking after Hong Kong, Macau, entire market. For such a case, for pandemic case, they're quite similar for very many companies in Hong Kong, even though it's a pandemic impact, but pandemic also helped some company really expand e-commerce, online business very fast. So my recommendation to this company will be, as long as there is a requirement or request from your key customer who request you to expand or build up a new office in a location that's new to you at the first time you establish the office, I think I can share some of my previous experience. Some of my clients who expand the business outside their homeland, they will making use of some cloud infrastructure instead of the physical one, because cloud services is more likely a very common practice for those companies who don't have IT, who don't have enough IT resources to set up those things in a very short time. And so I believe that first of all, this is a good reference for those companies who would like to set up a office outside the homeland. And second place is even those well-known service provider, even they are providing service to many customers, but for a due diligence purpose, it is good that you have a regular practice to do some cybersecurity assessment for those key applications while it is dealing with your customer, or if you have any mobile application that you allow your customer to download and then using those applications to connect to your services, it is highly recommended that you to test or ask some external service provider to help you to perform some security assessment before it is online and serve your customer. I think a pandemic is good or bad. It depends on whether you can making use of this opportunity and do your best due diligence to make sure your business is operating secure. So this is my point.
Well, drawing the strands together, this first step in the scenario we're exploring is all about the preparation in advance of the expansion and opening of an office. One, if you think of the key points that have come across, one is realpolitik. Where is IT security in the general hierarchy of priorities? It's not going to be high in the thinking of the business executives. At minimum, think about the engaging people who will be able to give the priority and attention that you as business executives may not have the time and attention to be able to do so. With that, also think about how you are going to manage the system in respect of an internationally operating business, as opposed to a business that operates within one geographical zone. And there, think about the benefits of cloud infrastructure and also the additional security that comes with cloud infrastructure if you are a young and agile business. One of the things you can think about here is that what we haven't thought about is what things like the things that cybersecurity experts would like you to think about in respect of a data breach response preparation. We haven't spoken about building up policies, procedures, incident response teams, and so forth. So let's see what happens when something goes wrong. If we move forward to the next slide, please. We're making an assumption here for, which is that now Source Secure has a CTO. The CTO gets a phone call, the IT system is down, we can't access our files, all we're getting is a pop-up screen saying, files are encrypted, please pay Bitcoin. Now, one of the things that Mike mentioned in his response was the interaction between in e-commerce, between different participants in a supply chain, which is another way in which you can become infected, a cyber infection, by virtue of ransomware or other threats that go through a platform that is in communication with each other. That appears to be what is happening here. So Brent, if I could come back to you and ask you, as a business owner, not necessarily thinking about the technical aspects of what has happened here to Source Secure, but as a business owner, what are your immediate priorities? What are you going to do in a situation where you realize that your business is now in a fundamentally awkward position and unable to function as usual? Brent.
Yes, sorry about that. I'd like to be able to say that I would open my desk drawer and pull out the cyber incident response plan. But the reality is, as a small, fast-growing business, it's pretty likely that I don't have one. And so, I think the first step, first and foremost, would be to try to understand what exactly happened, right? So basically, the CTO, whoever the local manager is in Milano, and then the person responsible for the IT setup on that side, whether it be an internal person or a vendor, they're my key point people, right away, to figure out what has happened or what is happening, and to do whatever investigation is required to get to the bottom of that. And once that is sort of in process, then I would reach out to the Italian authorities, whoever the appropriate federal authorities are. I'm guessing it's federal police or somebody similar, to notify them of what's happened and allow their cybersecurity people to assist us. And then I would reach out to our lawyers. In this case, probably I would call Padraig. And I would recommend others to do the same. Then otherwise, I would say once we have sufficient information to know that it's not an inside job, then I would notify certain employees that need to know, especially those who are customer facing. And then follow whatever the GDPR guidelines are regarding the official notification. I think it's 72 hours, if I remember correctly, for such an incident happening, right? So we would do that notification and then proceed from that to do PR or whatever public communication would be appropriate to make sure that all constituents are aware of what's happened.
I think what's very interesting in terms of your response there, Brent, is that your first instinct is to find out what is happening and can it be restored or remedied, and identify what some of those remedial steps might be. That absolutely is the first thing that you would do. It's the first 24 hours after an incident like this is absolutely critical. I mean, one of the questions you would need to understand is if this in a ransomware incident, you don't have access to your files anymore. So it's probably not just an issue that is occurring in Milan. It's probably an incident that has propagated across the entire, IT infrastructure and system that you've got, meaning that it's also affecting you in terms of your home base. And one of the important things there is to see, is there any self-help that you can do? And on that, I'd like to move to Guido and to ask, what would you do from a technical IT perspective? What kind of issues would you try and address in a ransomware incident such as this? So it doesn't appear, or at least it may or may not be known, but it doesn't necessarily follow that there's been a data breach here. But what is quite clear is that someone has been able to access your systems, encrypt the files, and prevent the business from operating. What are your first steps, Guido, as a technical expert advising in this situation?
Well, as Brent said, there are a lot of things going on here, and well, the key point here is, I think, to be prepared, because a good preparation could mean that you can could make the difference between a contained incident or a company-wide infection. Here, if we are talking here about a few workstations or a few systems that have been infected, I think that the first thing that you have to do, first of all, is to isolate those systems, because this kind of malware, this ransomware, they spread through the network. So the first thing to do is to isolate the systems that you think that they are infected. And maybe you have also to isolate, if you have any, isolate your backups, because you want to protect them and to be able to restore later on. And then, as Brent said, the first thing, then after that, the thing that you have to do is to consult a security expert, a ransomware security expert, because they will then access the systems. They will understand what ransom, what malware did you get, what strain of the ransom, and and to understand what did it do, and also, and most importantly, you don't start the recovery plan before you are sure that everything is cleared, and that every single computer, every single system is cleared.
Isolate, secure, bring in proper technical experts.
The key here also is preparation, because if you have a good plan, you can act immediately.
Yes. Well, one of the interesting things, and maybe just to hark back to something that Brent mentioned, and this is in relation to the engagement of lawyers. Quite often you would want to engage lawyers as one of your absolute first steps, as in you realize that there is a serious cybersecurity issue, knee-jerk reaction, engage your legal counsel. The reason for that is that that enables you to engage security experts who may well then benefit, the entire arrangement may well then benefit from the protection of legal professional privilege, but also in that issue as to whether or not you need to notify and what you need to notify. That's very much a legal issue and is something that the lawyers would become immediately involved in and advising on. Now, there is one question that is begging to be asked, and I've kept this for Mike. It's a ransomware. There's a ransom demand here, Mike. Do we pay?
It's a very interesting question. Most of the time when people are facing ransomware attack, the first thing they are facing is whether pay or not. Most of the time, this answer, should be no, but it depends. I bet one step and do a payroll. If I'm a CTO, my practice will be if I'm a CTO of that company, my practice every day will be, I ask myself whether today, if there is any attack, similar attack like this, whether my company is ready to whether my company is prepared for this kind of attack, whether if this kind of attack really happens in my company, whether my staff, my team, my IT people, my security people, they are ready for this kind of incident. If my answer is yes, I would say no worry about pay or not pay, because the worst cases, if I don't pay, we don't pay, then we already have planned to restore what has been logged, what system has been logged. We have already has a plan to recover our business with a very short period. Therefore, definitely we need not to pay. But if the answer is not or no at all, then you may think about to pay it. But I give you a warning, because most of the time, even you pay, your system or your file may not get unlocked. It's because of a couple of reasons. One of them is the guy set you up, send you the ransomware, might not want to unlock the file, even you pay. First situation. Second situation is he might not, you have paid him. He might not, that maybe there's a program bug or whatever, even you have paid, but he didn't receive it. Therefore, he wouldn't unlock to you. And the third thing is, he even don't know how to unlock it. Maybe he is a squid kitties. He just send you a ransomware by random. So the most critical thing is whether you are well prepared for this kind of similar incident. If you are well prepared, I would suggest you no pay, and then lesson learned and review all not good practice, and then make it a better one. And that's, I think, will be more suitable approach.
Thank you, Mike. And one of the things that's consistent with also the response that Guido gave is the importance of preparation. And if we move on one slide, just to where we explain a little bit more about the result of this particular situation. This scenario was based on a situation where it's based on a phishing attack, which is a very common way in which ransomware is spread. Now, if you think about how phishing operates, which is usually a user in respect of a platform or an IT system that clicks on a link or opens an attachment that's got malware in it, and then that propagates and infects the network. Now, in that particular situation, if you have, firstly and foremost, training so that the people within the organization understand the risk threat, understand the tell signs which are common amongst most phishing attacks, that is your first line of defense, really, because it is the human error that triggers these events more often than not. And then following on from that, then you look at the IT architecture and infrastructure, and you look at ways in which you can put barriers between whether or not particular attachments are screened and so forth, so that things that are obviously going to be a risk threat to the system don't get into the system. So there are things that you can do in respect of training, in respect of preparation, in respect of the design of your IT infrastructure that minimizes and mitigates the risk of these kinds of attacks. The other thing that is interesting here in terms of the design of this particular scenario is that it is something which happened not within or by Source Secure itself, but by a third party that was communicating with Source Secure. What that really means is that in respect of the training and preparation that you conduct within your own organization, yes, that's absolutely essential and critical, but it is not enough. You also need to be aware of the risk that is coming through your supply chain, right through from people who are supplying to you to customers that you yourself are supplying. This supply chain risk, particularly as a result of during the COVID era, has really grown rapidly and exponentially. And we're going to explore that a little bit more in the final step of this scenario. So if we move on to the next slide. This is a sequence which explores a data breach incident. And it is a pretty common situation that links to sensitive personal data relating to payments. So if you think of SourceSecure as being a B2B source and supply business, that means that it's going to have a payment function enabled within their platform. Now, many payment platforms start from or originate from open source software with proprietary software that's built on top of that and then licensed to the service provider. Assume a situation where there is a popular base or foundational open source software, but which has known bugs and defects with it. Moving forward to the next slide. SourceSecure purchases a license to a payment solution that's built upon this open source software, and then engages an IT service provider and integrator to be able to perform some customization services for their own platform. So in this sense, what SourceSecure is doing, as many businesses do in the e-commerce arena, is that they're outsourcing a core aspect of their business process. And they're relying on third parties in relation to securing that core system as part of their overall service offering. And moving on to the next slide, what happens then is that there is a vulnerability in the payment plugin, and financial data has been leaked or hacked to a third party and is now appearing on the dark web. So Brent, if I could come back to you, it looks like SourceSecure is having a pretty bad run of luck. In this particular situation, well, what I'd like you to speak to is this situation where, as an agile, young and growing business, a lot of what you do is outsourced to others. What does that mean in a situation like this? I mean, how would it be, at this point in time, that there is a problem where people are looking to SourceSecure, but in reality, is SourceSecure in a position to be able to answer all those questions when they've used third parties?
Right, so I definitely resemble that. I mean, BuyHive, my real company, is for sure in that situation, and it is not a very comfortable situation to be in, I can say. But I would also like to say that the kind of solution that you described in the case setup is a little bit Frankenstein to me. And I'm not an IT expert, but that also scared me a lot. So all I can really say, having been through this process multiple times on my own, is that you have got to choose your vendors very, very carefully, right? So you need to know about their reputation for quality, for stability, for reliability. I think that's pretty basic, but also for responsiveness, especially customer responsiveness. And you've got to have very careful review of the contracts that you're signing with them to ensure that you know that there is sufficient language in those contracts to protect you as the customer and the data that effectively belongs to you, so that you know what they're going to do if this kind of a situation occurs, right? And I absolutely don't believe for a second that most companies in this situation who are, let's say startup size or small and fast growing, I don't think most of them do this sufficiently well, but it is incredibly important. Because ultimately you are, it's the weakest link scenario, right? So, you're beholden as a company, and your reputation to a certain extent is beholden to this patchwork of vendors that that provide the different pieces of your solution.
One of the things that is a fundamental disconnect in this situation, and it is very much based on real world situations, is that insofar as the people who have been harmed and the whoever is facing towards liability, that's very much SourceSecure. They are in the hot seat. So the business is in the hot seat insofar as explaining to data subjects, explaining to regulators and so forth. but the vulnerability that gave rise to this issue arose because of other persons. And the liability and the responsibility of that may not necessarily flow back to those other persons. And that's going to, a lot of that is going to rely upon the contractual provisions that are in place as between, if you think of the three layers, open source is open source, but you're looking at the licensor, you're looking at the IT integrator and service supplier, and the contracts that they provided, and whether or not there's been a proper analysis in the flow of liability where they have accepted that if there are particular things they have done that are problematic, that they stand up and take responsibility and liability for that in terms of warranties as to the quality of their services and indemnification in respect of financial loss or other consequences that might arise. That may not help you ultimately with the responsibilities to data subjects who now have their personal data, credit card data and so forth appearing on the dark web. But that from a business perspective it's as you said, it's a Frankenstein situation, but actually a real situation that I took from a case that I advised on, with a real fundamental disconnect between where the risk ultimately sits and where the liability sits, as opposed to the persons responsible. But if I was to move on from that, Gita, in this situation where there is a data breach, what are the first things you would do when you are contacted in order to try and secure the situation from an IT perspective?
Okay, well, okay. If we talk in general, not this case because this is a specific case, what I would do is first of all analyze the data. What data has been leaked, and where, so that I can understand where that data was stored in, where that data was stored, so I can secure the systems and also understand what happened, because it may be, for example, a brute force attack to the system, or it may be like in this case, we don't have these systems that that hold this data because the data was held by our supplier, for example, or even it can be also some internal employee who leaked that data. We don't know immediately what happened. And so the first thing to do is to understand what data was leaked, and then from there, depending on the situation, you can then act. It's interesting to notice that a few years ago there was a report from FireEye that found out that almost on average it took 146 days for companies to find out, to detect a breach. And most of them didn't realize it until it was too late or until it was already news. So even in this case, I think it's very important to be prepared, and to put in place all the systems that can help you understand what happened, because you may even never know what happened if you don't have the systems in place that can tell you and audit all the things that happened into your company.
And Mike, building on that, I mean, what we have here is a situation where there is personal data and important, potentially valuable personal data, where it shouldn't be, as in it's already out there and is potentially being traded and sold between bad actors in a nefarious world. What can we do about that? Has that horse bolted? Is there any remedial act we can do? If we can't retrieve the data, what should we be doing in terms of trying to help and support the data subjects who are affected by this?
Okay. First of all, if the company is get prepared before this kind of incident, it wouldn't happen. But I would say, first of all, if this is really the case, the data is exposed to somewhere which is out of control from the company itself, I think the first thing is to make those impacted customer or related parties to get notified and also report to the regulatory, and also get all necessary steps to minimize the loss, say to ask the customer or contact the, say if there is credit card, contact the credit card center, there is some breaching, data breaching, and then there is some loss of personal information, and try to stop and minimize the related losses. But back one step, if I'm a CTO of the company again, if I'm asking my team, my department whether they're ready for this kind of attack, in detail, there are 3 things that this scenario has mentioned. First, third party. Second, open source. Third, sensitive data. For the third party, I think it's key things that we need to have a due diligence to assess the third party, whether they are performing the good practice, good security practices, whether they know this is critical for the operation between the company and our company. And second is that the open source. The open source is talk about whether the open source program is good enough to be used or secure to be used. So a third-party independent assessment should be applied. And the third thing is the sensitive data. All sensitive data, no matter it's personal data, credit card data, should be encrypted while it is at rest or in transit. If all this has been done, I would say definitely if this kind of unlucky thing happened for your company, you wouldn't be that headache to think about how to minimize the loss. But in case that is so unluckily this happened, the data, even if it is linked to the bad actor and then putting somewhere, there can be no way these sensitive data to be resell or to be impacted by the related parties. So that is my point.
And building on that, one of the things that two other points, one on preparation and protection, and another in relation to what you might do in respect of remediation. On the protection side, if a business gets to a particular size or scale, there will be an inflection point where they should seriously consider taking out cybersecurity insurance, because with that insurance program will become the ability to access resources that will be very helpful in a situation where a data breach happens. Because once a data breach happens, if you haven't prepared for it, you are immediately in a situation where you're really in a crisis and you need to be able to manage and respond to that. Being able to call on, firstly, knowing that certain elements of loss are going to be covered, but also that there are mandated professionals who can step in to help and guide you in that situation is something that is valuable. On the remediation side, one of the other service providers or experts that you would or need to consider involving in a situation where data, personal data, sensitive data, belonging to your customers or other people in your supply chain are concerned, is whether or not you want to deal with a public relations expert who can become involved and guide in respect of the messaging that is useful and important where a data breach incident has occurred. And part of that may also involve in engaging a support or service helpline to guide people in respect of what the consequence is to them of the data breach in question, including some form of reporting as to whether or not their specific personal data is actually appearing in various sources around the world, so that these people have a degree of comfort about the real life impact. But that actually brings us to the end of this scenario. Many of the features of this, the incidents that we've described over this, the course of the last 40 minutes or so, are based on real life cases. But in the course of 40 minutes, there's only so much that we can cover. To recap quite briefly, if you think back to Francis's presentation, e-commerce is a business that is growing very rapidly and replacing bricks and mortar retail in respect of business flows generally. This has also led to a boost and increase, significant increase in respect of payments that are conducted online. With that, that makes e-commerce as an industry particularly vulnerable and sensitive to cybersecurity risk. And this arises in terms of international expansion of those businesses, supply chain risk, and risk in respect of the payments conducted over e-commerce platforms. We've touched on a number of those issues. There's a lot more we could do, but now I will hand back to Andrea with thanks to the excellent panel that I've moderated, and leave it with Andrea to close this event.
With thanks to the excellent panel and with thanks to the formidable moderator, I would say, Padraig, you really represent PrivacyRules in the sense that you are a lawyer with high sensitivity for technology issues, for cybersecurity problems. And I'm very pleased that you also mentioned in the closing the importance of communications. Indeed, especially in the case of a data breach or a data crisis of any kind, communication is very important because your most valuable asset that is at risk in a data breach is not per se the value of the data. I mean, they can be almost insignificant, but it's the customer reputation. So if you suffer a breach or any kind of incidents and this goes in the out, actually the damages that it might have for your business are much higher than any cybersecurity cost of the kind. In this regard, our 3-day overflight on privacy and cybersecurity on e-commerce, when landing in Europe yesterday or having a layover in Europe yesterday, we were addressing specifically this topic with investors and also with startuppers. Brent, thank you for being there. You represented really some of the concerns and the real problems of a startup or of a young business. When you say, I have priorities, I have X budget, and I need to factor this budget with my priorities, and perhaps cybersecurity or even data protection compliance might come not at first. Yesterday, we explained why, in our opinion, it should be factored immediately, and some mitigation measures should be already put in your plan also because privacy by design is a concept that we cannot escape from. And privacy by design implies cybersecurity. So for the audience, we will publish also the sessions of yesterday. So not only you, Brent, but definitely whoever is listening to us out there can hear about the kind of advice we have in this regard. Special thanks again to Brent and also to Francis, who are guest speakers of PrivacyRules, whereas Guido and Mike are members of PrivacyRules, as of course, Padraig is also chairing one of our committees. I warmly invite everyone in the audience to find their contacts in the brochure of this event, as on our platforms. www.privacyrules.com. There is unfortunately no time for questions, so please send them over to info@privacyrules.com, and we will be very pleased to answer, and we will actually pass your questions to our speakers for answers on their side. And please, in any case, subscribe to our platforms in order to follow the next events that we are going to organize. Francis was with us already before, so thank you, Francis, for being with us again. It's truly an honor and a privilege. And hopefully, Brent, maybe next we can analyze how, from the perspective of a young entrepreneur, in the growth of your business, actually you started factoring, and you can pass on your know-how to new and smaller startups, and how and where to put data protection and cybersecurity into your strategies and operations. Once more, thanks everyone. We will publish these webinar soon on our platforms. Padraig in particular, thank you for this fantastic moderation, as the one of Jihong before. And let's stay tuned, because obviously data is growing, the data and the digital business is growing. So there is a lot to discuss more in the future. Thank you.
Thank you very much.
Yeah, thank you very much for having me.
Thank you.
Thank you.
Thank you. Goodbye.
Bye.
Bye.